you go. We have got Brian Monk in the house right now from the BCN law firm. I tried to say that real slow so you'll get it. The initials are B as in Boyette, C as in Cummins, and N as in Nalos. And that is your law firm with offices Winter Park, Claremont, Lakeland, and now right there in my hometown of the Villages. Winter Park, Claremont, Lakeland, and the Villages. And if you ever want to get a hold of the BCN Law Firm, it's really easy. 855-LAW-2020. That's it. 855-LAW-2020 or 352-394-2103. That's the headquarters office. And we love this show. We invite you to call in any legal question you've got. If it's not right down Brian's alley, he'll know which one of the attorneys back at the office can help you out, but he'll give it a good go, a college try, as we say. We're taking your calls right now at 855-297-9696, 855 toll-free, 297-9696. And don't forget, you could text the program. That's really easy. Get out your smartphone, go to the messaging app, right there where it says recipient. Instead of a phone number or a contact name, just put in 21232. 21232. That is a very cool texting feature that we have here. And you can get traffic alerts on that, weather alerts, you can get all kinds of cool stuff. But it's also the way for you to ask a question of Brian Monk. And Brian, by way of introduction, we get new listeners every week. Tell us what you specialize in.
Over at BCN, I practice primarily in the areas of marital and family law, which is divorce, post-judgment modifications, paternity cases, child support matters, things like that, sometimes prenuptials, postnuptials, marital settlement agreements, and then also in the area of criminal defense. I'm a former prosecutor. I've handled about 50 jury trials to completion, and so that's a part of the practice that I've kept going as well. And unfortunately, a lot of times we see an overlap between family law and criminal defense. Sometimes there's some domestic violence issues. And then that leads into sort of a third area that's kind of a hybrid of those, which is domestic violence injunctions, commonly known as restraining orders. So we see quite a few of those as well.
It seems to me that it's either the crime of the day in the eyes of the news people or something. But in 61 years, I can never remember as many stories nationally and even locally right here of domestic violence. It's getting crazy out there.
A lot of times when people are having difficulties in their marriage, there are legitimate domestic violence issues that arise. And a lot of times when the dust settles, the parties usually wish for those kind of things to go away and for them to kind of make up at least enough to get along and co-parent with the kids. So a lot of times those charges that flare up end up going away. So some of them are legitimate, and then unfortunately, sometimes people make things up. They get it in their head from seeing something on the news or TV, or sometimes maybe some bad advice. Hey, if I allege that this, and this happened, then I'm going to get everything. I'll get the kids in the house, and you see incidents of people, frankly making things up. And you might say, well, how do I know that? Because I've been involved in cases where people later admitted, they made some things up.
Let me ask you this. On the other side of that coin, sometimes when it gets to the ultimate violence, that one or two of the spouses is dead, it could be murder-suicide. It could be just, the husband killing the wife or the wife killing the husband or having him killed. In the time leading up to that, does this often happen because people do not act and seek legal recourse and seek the courts and the law enforcement? And the woman might say, well, I'm afraid if I turn John in, when John does get out, he's going to come and beat the crap out of me.
Hard to say. I would say, and I do have a background in some mental health counseling as well. My reaction to that question is there's a lot of mental health issues that people have that are not treated or that are not adequately treated. So oftentimes you'll have people that they're in the midst of emotional problems in their marriage, but they might also have a mental health condition that's either overriding or underlying that and adding to the problem. And then frankly, a lot of times there's also substance abuse issues too. So it's not really that unusual to have a situation where you've got the emotional component of emotional problems in the marriage, maybe a mental health problem on one or both sides of the parties, and then finally maybe a substance abuse issue as well.
Wow. Now, if you've got questions, we realize this is a very, very sensitive area. But if you do have questions about domestic violence, whether it be parent-child or whether it be parent-to-parent or whatever, or maybe it's elder abuse, you can give us a call, and you don't have to say it's your family. You can say the family down the street, a family you know in Kansas, but it's the advice we want to give you. So please don't feel shy about making the phone call or texting us at 21232. That's 21232. If you just text us on that, you have about 160 characters, so you might have to send 2 or 3 texts. There's no problem with that. We can put those right together for you. Old Tim can, and he'll get it on the air for you with Brian Monk of the BCN Law Firm. Touch base with us right now, 855-297-9696. Let me go back to domestic violence. Is it a case now when law enforcement comes to a home and there's been a knockdown, drag out between the two parties? I would say husband and wife. We have a lot of people living together in these days. So between two people, is it true that one of them has to leave the home?
More and more in it, and again, I've been involved in these kind of things at least since '06, and it has changed since then. In the past, it would be that the law enforcement would maybe separate the two of them, or say to someone, "Hey, you need to go spend the night somewhere else. You need to go away from here." But yes, last few years at least, we've heard more and more from law enforcement agencies that they're going to go ahead and take someone, if not both, into custody. If what they're usually looking for, though, is more than just an allegation. They're going to be looking for an allegation of a battery, and a battery is defined as an unwanted touching. So a lot of people have the misconception, and I've had trials that involve battery. People are under the misconception that a battery means somebody's got a bloody nose or a black eye or was knocked unconscious, some significant. Frankly, if it's a serious enough battery, it can be a felony battery. But no, simple battery can simply be an unwanted touching, an unwelcome, unwanted touching. And so in, domestic situations, somebody's grabbing a phone from someone else, or someone gets scratched, or someone gets pushed or shoved. But anyway, when law enforcement are coming to the scene, if there's an allegation of an unwanted touching, and if they can corroborate it in some way, they're going to take somebody in. And if they can't corroborate it, like say they both say that the other hit the other, sometimes they'll take both of them in, and they consider that their job is done on that part. They have a police report that involves each person is alleged the other was the aggressor. Each person may have a mark on them, so they bring them both into custody and then let the legal system sort it out from there. And those are scenarios, again, like I alluded to earlier, a lot of times when people are living together, married or otherwise, and they get into a situation like that, it's not at all uncommon for the people after the dust settles to say, you know what, things got heated in that moment, but we didn't really foresee it going this far. Hey, the state attorney's office is threatening to take this charge and run with it, even though I, the victim, don't want them to. And they realize it gets sort of out of hand, out of their control, beyond what they wanted to have happen. And so a lot of times these cases end up going away. Sometimes they don't, depending on how serious the harm is that's involved. Charlene,
we have 3 minutes to spend with you. We may have to hold you through the break, but go ahead and pose your question right now.
Okay. I was wondering if there was legally anything I could do about my ex. We were married 24 years, and I got a letter from an old friend of ours that said that he is fixing, in which he has already, he's left the state of Florida and moved to California, and he's about $50,000 behind an alimony. Is there anything I could do about that?
Why do you want him to be prevented from leaving the state?
Pardon?
Why is it that you want him to be prevented from leaving the state? Because he owes you alimony, or is there another reason?
He moved out to California, so he wouldn't have to pay alimony anymore. But he's already like $50,000 behind. I was wondering if I could do anything to get him back here, or somehow to get him to get caught up on the back alimony.
Well, in a family law situation, the court isn't going to say to the other party, you can't leave the state. But they are going to have regulations about relocating when it comes to children. So that's where relocation issues commonly come into place. A court is not going to tell him, that he has to stay in the state of Florida. However, you do have remedies for enforcing the alimony. And so what you're going to want to do is seek counsel about having him held in contempt for non-payment of alimony, or finding some other ways to garnish his wages or get what is owed to you. So that's what you're going to want to do. It may be that you have to enroll assistance in whatever state he goes to execute that order. It's not uncommon for other states to have to do what's called domesticating an order and then enforce it in their state. The states have the full faith and credit they have to give to the laws and orders and decrees of the other states. And so you may end up having to, follow him through wherever he goes to enforce your alimony order. You can attempt to enforce it where you originally got it, and you can attempt to enforce it where he goes. But as far as keeping him from moving, based on what you told me, no, I don't think a judge is going to do that, man.
All right, very good. We're going to take a break, and when we come back, we have a text up there. Last digit is 8, and we will go ahead and read that text. When we come back, it's interesting about grandparents and visitation. We'll be back with more. Give us a call. You can chime in. Again, you don't have to use your real name, 855-297-9696. You don't even have to give your real town if that would hold you up. 855-297-9696, or text us at 21232. 21232. And welcome back to the show. This is the Law 2020 show, brought to you by your friends at the BCN Law Firm. They have offices Winter Park, Claremont, Lakeland, and a brand new Villages office on Highway 466. BCNLawFirm.com. BCNLawFirm.com. And if you are uncomfortable making a call on the air or texting us or using the open mic feature on the all-new News 96.5 app on your smartphone, then you can go ahead during the week and just give the law offices a call for a few minutes of free legal advice at 855-LAW-2020, 855-LAW-2020, or 352-394-2103. Let's go back to the phones. And, John, how can we help you?
Yeah, it's a good question. In the past, I got accused by an ex of domestic violence, and later it was through court maneuvers. It was determined that she had lied about the situation, and the sentencing of it was tossed. The cram novus was supposed to be filed, but no one would file it. What is the impact on a person's rights of owning firearms as a result of that?
So you're saying there was a charge, but it was dropped?
No, there was adjudication through trial and through appeal process, and then there was technical issues that the court found that they never had a proper jurisdiction, and the sentencing was kicked out, but the adjudication was left and was said it had to be done, addressed through coram nobis, but couldn't find anybody to take that issue up.
Yeah, so if you have the adjudication on the battery, it does affect your firearm privileges, as you know. It sounds like your situation is sufficiently complicated enough where I would want to take a look at the paperwork and the trail of what got you to where you are. I'm assuming you're wanting to have firearms now, and you're hitting a block on that. Is that what I'm understanding?
Yes.
Yeah.
Yes, I don't have anything to do with the person. That person is a problem that just won't go away. And through many years of legal, even getting restraining orders against the person who made the false allegations. And I'm having this problem where I want to be able to engage in sports activities involving firearms, but I'm being blocked because of it.
Yeah, and that's having to do with a background check they're doing. So the federal law that requires the background checks, there's something in that background check that's coming up, most likely this conviction, that's a block to you being able to access that. So that's something I'd be happy to sit down with you and take a look at the paperwork and see if that's something I could help you with at some point. If you give the office a call, we can set up a time to do that. I'd be happy to help you with that, John.
Okay.
All right, John, thank you very much. Okay, we have a text here. Do grandparents have any visitation rights in the state of Florida? Thank you.
Thank you for your text. There's actually a statute that is called Grandparental Visitation Rights. It's Chapter 752. And what that says basically is that the grandparents can petition the court to have some time with the children or visitation rights if one of the three criteria are present. The parents of the children are divorced, their marriage has been dissolved, or one of the biological parents has deserted the child, or if the child was born out of wedlock and the parents never marry. Other than those circumstances, Florida law, and there's been some cases on this, has pretty firmly stated that if the intact marriage, the parties in the marriage don't wish to have contact with the grandparents, then there's nothing the grandparents can do to get around that. And I know that's a big topic in Florida with a lot of grandparents in Florida, and that's an area of the law that's been addressed and assessed at length as well. But that's the current state of the law on that. So thank you for that text.
Yeah, thank you, texters. And if you don't know how to get a hold of us on that texting feature, it's a little bit out of the ordinary because it's relatively new, but it's called the Mowgri. And how you get that is you just simply go on to your texting, like when you text your friends or your office workers, and you just put 21232, 21232 in the recipient level, and then you have the area to ask a question like these folks did, and theirs was only 2 lines, and that makes it good. Go right to the point, and you got it. You can call us at 855-297-9696, 855-297-9696. Let me ask you this, Brian. If you have a neighbor that you hear a lot of screaming and yelling coming from their house, and you hear, some crashing of glass and stuff like that, are you allowed to call 911 and ask that it be investigated?
Oh, yes. That's a lot of times how the police are called out, is something like that someone calls. A lot of times when there's independent witnesses, that's going to increase the chance that somebody might actually end up being taken away as well.
Yeah. Now, I can imagine, because you mentioned that sometimes these calls are made out of vindictiveness, but what is the police thoughts when a child calls and says, Mommy and Daddy are always fighting and Mommy hit him over the head with a frying pan?
Well, if they come out and investigate that and there's, corroborating proof that that's what happened, someone might get taken away. And then if more likely than not, though, what would happen there in that situation is DCF would get involved. Ah,
very good. All right, we're down to less than a minute. Let me give you this contact information one more time. It's BCN. That stands for Boyette, Cummins, and Nalos. You can go to their website right now at bcnlawfirm.com. And you could always call them. They have offices Winter Park, Claremont, Lakeland, and a brand new office in the Villages for all those of you up in that area of Marion, Sumter, and Lake counties. You can call 352-394-2103 or 855-LAW-2020. And I got a text on my phone a minute ago, Tim. Somebody says, what numbers are law? So I looked on my phone. It's 855-529-2020, Law 2020. We'll be back after news, traffic, and weather with Dave Wall. All coming up. Hey, welcome back to the show. Yes, indeed. We're taking your text at 21232, 21232. And you just put that in the recipient line of your smartphone messaging app. And then down in the field, you'll have about 160 words. We often do text you back that say that you used more than the 160, and we don't know your full question. So that means if just go ahead and send the rest of it, and we'll ask you, please send us everything after a certain word. So be watching your text, okay? Now, we're also taking your calls at 855-297-9696, 855-297-9696, and we're talking about this unbelievable outlash of domestic violence that's been going on, not only between spouses, but between parents and kids, or between, those who are just dating. The Ray Rice incident comes to mind. And, of course, then we've had recently in the news a man charged with killing his girlfriend's daughter. So, this is something that's very prevalent in the headlines right now. Let me ask you this. Mores are different in different types of the United States. So in the South, they may think less of swatting a kid on the posterior as a punishment, but in some of the other states, they would think that is going beyond. Now, I'm not talking about taking a switch to them and drawing blood, as in a recent case that made the national news, Adrian Peterson case, and that was the alleged crime. But, come on, there have been instances, even in Central Florida, where somebody has been arrested by a sheriff's department for having a little knockdown drag out with their son. When I was growing up in the Ozarks, you hadn't come of age until you had a fight with your father.
Yeah, and I don't want to say this is a bright line rule, but for some law enforcement it is. If it's leaving marks, then you're crossing the line.
Yeah, I can see that.
From corporal punishment to child abuse.
Mm-hmm.
So people bending the child over their knee and spanking them, swatting them on the rear, still very commonly done. I think I've heard a study recently that the majority of people still accept that to do with young children, which I was surprised to hear.
Boy, in the media, you wouldn't think that because the media's, like way down on it.
Wouldn't think that, but I heard that
wow.
that a majority still believe in that and endorse it. And I'm not here to endorse it one way or the other, but I've had some criminal defense cases like this before, and in the case that I had, that was sort of the bright line. There was, is this swatting of the child on the rear? Is this leaving a mark? Or is this something that's meant to correct the child's behavior? And
wow.
I know that is a hot topic. And if a person is disciplining the child that way, and they're not doing it out of self-control, but if they're doing it out of anger, obviously there's a greater likelihood that there's going to be a person crossing that line from discipline to abuse.
I can imagine that. Yeah, I can say once you get angry, things tend to get out of control. But very, very interesting. And of course, then I remember being in junior high or 7th and 8th grade, actually, in a 4-room schoolhouse in Missouri. Yes, they had those back then. But the principal administered the Green Hornet or the Red Hornet just about every day to somebody's behind, and that was a paddle.
Well, and I also, again, listening to the radio recently, heard that there's still some states where it's legal and permissible for public school teachers to discipline that way, and that it's being done. And I was surprised to hear that, too.
Very surprised to hear that. Larry, how can we help you?
Good afternoon, gentlemen. I have a friend of mine who did a nonviolent crime, but it was a theft. And it was a felony, and he never served any jail time. He just had to pay a fine, and it was his first offense and all that. And since that time, that was about 26 years ago, and he's looking to restore his civil rights, and I think it was a theft of like $600. And, there's excuses why somebody does something, but anyway. And I'm just wondering, what is the process for somebody getting their civil rights restored after something like that, where they could vote and maybe be able to go hunting or, own a firearm?
Yeah, thank you for your question. That's determined in Florida by what's called the Board of Executive Clemency. And there needs to have been no violent offenses, as you indicated. There's a series of other checklists. They can't be a habitual violent felony offender. In some cases, you can have the rights restored without a hearing if the appropriate paperwork is completed and filed. There has to be, depending upon the level of offense, in your case, it sounds like your friend it's been 26 years. So for some levels of having your rights restored, you have to go 15 years without an arrest and be crime-free. And at that level, they require a hearing. And then, depending upon how serious the crime is, they may involve a full investigation and a hearing. So your friend can visit the Florida Clemency website. That's fpc.state.fl.us.
Okay.
Certain areas of the law, you can't really rely on what you look at online, but this is one of those areas similar to sealing or expunging a prior arrest that's pretty well laid out online through the government agencies themselves. Not a bad idea to have an attorney involved. I recommend
That's what I was going to ask. What type of attorney would that be?
Criminal defense attorneys can help with this. Usually you're going to have, I would say, a criminal defense attorney. Yeah.
All right. Wonderful.
Yeah. Okay. Good luck to you and your friend.
Thank you. All right.
Thanks.
All right, very good. And we are taking your calls at 855-297-9696, 855-297-9696, or text us at 21232, 21232. And what are some of the misconceptions that people might have about domestic violence out there that they might call the police and the police might arrive and say, no, that's not exactly what this is? But where does verbal abuse get into it?
Well, certainly to answer the first part of your question, I think in the past anyway, one of the biggest misconceptions was that anytime the police come out and anytime it's a male-female situation, the male must have done it, the male gets carted off. Okay? I think that is changing. I think, and I've talked to law enforcement officers about this, and just in seeing it in the practice, more and more you're seeing females getting arrested as well in domestic violence situations. So, I don't know. I haven't conducted a study on this, but it seems like more and more in society and law enforcement and the criminal justice system, people are recognizing that both males and females can be aggressors in situations. So that's one misconception I think is slowly kind of changing, that either one can be the aggressor, just because. And even in a situation where the man is 6'3" and 250 pounds and the woman's shorter, the definition of a battery is an unwanted touching. If a short woman throws a plate across the room and cracks him upside the head, doesn't matter how big he is, and that's a battery. Sometimes those things happen. Verbal, usually a person's not going to be arrested for verbal. A lot of times in our domestic violence situations, domestic violence injunction situations, you'll have allegations where, this person said this person said that, this person said they're going to kill me, this person said some kind of strange comment that means harm to the the alleged victim. And, under the law, words alone shouldn't be enough to obtain a domestic violence injunction. It has to be words accompanied by some action of an apparent ability to carry out a threat, or the person has to feel imminent harm. And so,
all right, a reminder: you don't have to use your name, and you don't even have to say it's you that needs to benefit from the answer. If you want to call us and you've got a question about domestic violence, about divorce, you can go ahead. Or if you have a criminal question, because Brian Monk specializes in that as well, give us a call at 855-297-9696. You don't have to use your real name. You can say, my cousin up in Missouri has this problem. Text us at 21232, 21232. We'll be back with more, but Dave Wall has three big things you need to know. Hey, welcome back. It is the Law 2020 show. That's right. Bringing law into focus right here on the radio. Boyette, Cummins, and Nalos. That's the BCN law firm. 352-394-2103 for a few minutes of free consultation anytime, or 855-LAW-2020, and law translates to 529. So you could say 855-529-2020. And they have offices in the Villages right there on 466. That's kind of the 50-yard line in the Villages these days. Lakeland, Claremont, and Winter Park. And let's go to Greg. Greg, thank you for calling the show. Callers make this show very interesting. What is your question?
I'll make this as short as I can. Dealing with two young children, a 3-year-old and a 7-month-old, and the children have been staying with the grandparents for the last 5 months or so. The father has suddenly showed up back on the scene and wants to take control of these children. The mother has signed off on her parental rights. Would DCF take those kids out of the home of those grandparents where they've been stable for the last 5 months until this is all worked out? Or Can you give me some guidance as to how that would work?
Well, and part of it is finding out how you all got to this point, but rather than going into the long backstory, I'll just say this. The Florida law has a strong presumption for the rights of the biological parents, but that starts to change when there's a detriment to the children involved. And I'm sure there's a story as to why the biological parents, why one has signed off her rights and the other doesn't have the kids full time. But usually the aim of a dependency case, and that's often when DCF is involved, is when there's a Chapter 39 dependency case. Usually the aim of those cases is to reunify children with the biological parents. If it can't be done, a possible outcome in a dependency case is to terminate the parental rights of the child, of the parent with that child if there's ongoing harm, or they may simply keep the case in a posture where the kids are placed with someone else, either foster parents or extended family members. So what the court's going to be looking for is what's in the children's best interest. Is it possible to reunify the kids with the biological father? A lot of times, if there's a reason the biological father's not in the kids' lives, the court will put together a case plan, series of goals that the biological parent has to meet to have more and more time with the kids and ultimately be reunified. Is that something that's going to happen overnight? No, he's probably not going to just come upon the scene and snatch them back overnight. And again, I don't know how you all got to the point you're at, but if there's court involvement already and there's already a judge or a magistrate involved in overseeing this, the father, if he's excluded from the kids' lives for a reason, there's going to be some kind of a plan in place for reunification.
But during this time frame that the children would be removed from where they are now and put in DCF custody?
Well, no, because I assume, and I don't know the backstory of how we got to this point, but I assume there's a court that's placed them where they are already. If you haven't gotten to that point, then someone needs to get involved. The grandparents can file under Chapter 751 a request for custody by an extended family member, and that can be a court case that can be started to formally place the children with the grandparents if that hasn't been done yet.
Again, our only concern is like you said, it wouldn't happen overnight, but during the interim, would the kids be removed from where they're stable now and put into DCF custody, or that's just a case-by-case basis?
Yeah, for them to be removed, there's going to be court involved in one way or the other. So you all just need to figure out if you need to get proactive in involving the court, or if he's going to have to get proactive in involving the court. If there's no judicial involvement at this point, then I would say the grandparents might want to file something to get court protection for leaving the kids there with them. And if there's already court protection there, then the burden's going to be on the dad to intervene and show the court he's able to have the kids.
You're right. We won't go into the whole backstory, but the dad is definitely no good. So
yeah, I mean, it sounds like a good time to get an attorney involved and take a look at your options. And more and more these days, this is a common scenario.
All right. Thank you very much for the call there, Greg. We thank you for that. How many times do you run into situations where the parents, and maybe even like in this case, the grandparents, and I'm not saying that's what happened here, but maybe they'll just sit down at a family dinner, or maybe the two parents will call each other on the phone and say, you know what, let's just change this weekday thing to, why doesn't Sally stay with you 3 nights a week and stay with me 2 nights a week and then the weekend? And then next month we'll reverse it. And we'll just get along, and that'll be our decision to make. Without them running that through the courts, is that kind of a recipe for disaster?
Not necessarily disaster, but people will end up with something they didn't envision they were agreeing to. They may think they're just agreeing to change a time-sharing arrangement, but they may not realize it has an impact on the child support as well. And this last caller, reminded me of something I wanted to clear up on the air with regard to the grandparents' rights. I was referencing Chapter 752, and I realized we were talking about the history of grandparents' rights in Florida, and I didn't complete my thought earlier. The statute that is still in existence, 752, that lays out grandparents' rights, has been declared unconstitutional by the Florida Supreme Court in several Florida cases subsequent. But this last caller has hit upon the tool or the device that is able to be used by grandparents in Florida courts these days. And even though Chapter 752 is unconstitutional, under 751, a grandparent can come in under what's called custody by extended family member. And when there's a situation where the child's been with the grandparent and they want to keep having the rights and responsibilities of that child, they can petition the court under that theory. And there's also the theory of concurrent custody by extended family member. Some situations, a parent of a child may want their parent to be involved and help. And so there's actual formal way to do that as well. So when the person who texted before and said, are there grandparents' rights in Florida, that they're not the rights that the grandparents wish they were there, that they could just petition and see the kids, but there are tools and methods involved where a grandparent or any other concerned extended family member can be involved in raising and caring for the children.
All right. Thank you, Brian, for being our guest this week. And, of course, we always look forward to our visits with the people from the BCN law firm. One of these days, I want to get, like 7 of them in here and have like a big panel. We'll work on that. Yeah. All right. You want to get a hold of them during the week, 352-394-2103 or 855-LAW-2020. That translates to 855-529-2020. Winter Park, Clearmont, Lakeland, and the Villages, BCNlawfirm.com.